Good morning. This is Victor Sahn from Kupetz. Really happy to talk to everyone. Really appreciate everybody who has come into the seminar, to the webinar. My partner, David Kupetz, will be joining momentarily. He has had some first day hearings on a Chapter 11 he filed a few days ago that were scheduled before Judge Barish. So David will be coming into the call, I'm sure, very shortly. So for now, you'll have to bear with me, which hopefully won't be too much worse than him. This is a program which we have entitled Navigating the Fiscal Impacts of the COVID-19 Pandemic in the Middle Market. Let's go to slide number 2. One of the interesting developments from a case law standpoint has been the idea of PPP loans, which Congress authorized back in March. And those loans were specifically referenced to the Small Business Administration as being the administrator of those loans. The Small Business Administration has a policy that appears on the face of its applications, which says that they don't make loans to debtors in bankruptcy cases. This has fostered a great deal of litigation around the country. Particularly, I've seen some decisions from Texas, but at the last moment, in addition to our slides, as part of this program, because it's an interesting area, I've attached a recent decision on June 10 by bankruptcy judge Whitman Holt. And Whitman Holt is a former partner at the Cletuchin law firm, and was without any doubt until his very, very recent appointment to the bench in the state of Washington, Eastern District, I believe, the smartest young bankruptcy lawyer I had met. And, you know, the reference to young is hardly a qualification or caveat. He's one of the smartest bankruptcy lawyers I've met, period. And he decided that in his middle 30s to ascend to the bench. The decision, which is attached, is entitled Astria Health versus SBA. It is cited at 2020 Bankruptcy Lexus 1720. It enjoins the SBA from refusing to process the loan or make the loan based upon the fact that Astria Health was in a bankruptcy case. He not only granted a preliminary injunction in favor of the debtor, he also denied a stay pending appeal and certified the matter for direct appeal to the Ninth Circuit Court of Appeals. So I found it particularly interesting. He dictated his findings of fact and conclusions of law on the record at the hearing. They are 36 pages in length. They are very detailed. A great deal of law cited, and I think it's a good guide to the issue and a very, very good case to look at given who wrote it for anyone that comes up against that issue with regard to your debtor clients. There has been generally, as the slide indicates, an acceleration of Chapter 11 filings, I think, as people are generally aware, by large retailers, energy companies, and fitness companies. And the large retailers are almost all, if not all, mall-based retailers, and they include J. Crew, Brooks Brothers, Lucky Brand Dungarees, Ascena Retail, which is a 2,200 store chain that is primarily known for Ann Taylor and Ann Taylor Lofts, Tailored Brands in Texas, Lord & Taylor, J.C. Penney, Neiman-Marcus. The list is almost endless. What is also, at least from my standpoint, also unfortunately endless, are the prepackaged nature of these cases. We have represented half a dozen major suppliers of 4 or 5 of these debtors. We're sitting on a couple of committees in those cases. Those cases are pending in either Delaware, where it concerns the retailers. They're pending either in Delaware or the Eastern District of Virginia. And if it's an oil and gas case, they're being filed in the Southern District of Texas in Houston. And basically those 3 jurisdictions, from my cynical standpoint, are trying to outdo each other in their friendliness towards debtors so that they will continue to attract cases filed there. In the Lucky Brand Dungarees case, the debtor came in on the first day of the case with their standard 87-page DIP financing order that contained all kinds of findings, all kinds of super priority rights, lien rights, releases of insiders without any disclosure, without any bankruptcy schedules or statement of financial affairs. In short, without any information that would justify the granting of the liens that this particular 87-page DIP order provided for. And when I had the temerity to object to it, it took the judge little or no time to determine that my objections were without merit, that there was a basis for the order, there was an evidentiary basis for the order, and he signed and entered the order, which, as I say, granted lien rights on claims against insiders on all avoidance actions, I think in a way that the law can't possibly support. But it was granted very, very quickly and easily. And the reason is that what's being done is that these players in these particular cases that I've mentioned, which include the debtors, the lenders, usually the equity holders, and usually one of the major landlords. You have Brookfield, a major mall owner, and particularly Simon Properties, a second major mall owner, sponsoring these sale transactions. The sale transactions are all put together before bankruptcy is filed, and the bankruptcy gets filed and are presented for consideration and approval on a very hurry-up basis. And the bankruptcy judge, particularly in Lucky Brand Dungarees, approved a sale and a release of avoidance claims, which guarantees that unsecured creditors will realize zero on account of their claims. And I think from the judge's standpoint, these suppliers who are, in Lucky Brand's case, going to lose well over $100 million cumulatively, should just be happy to have a customer going forward, because the judge believes it's his job to save thousands of employees' jobs, to save leases that can be saved for locations that will be preserved, and to deal with this COVID situation, which has accelerated the filings by these entities, which would have filed anyway at some point in the future, but are filing now because COVID has made that a cash flow imperative. And certainly these parties who are baking these sales in advance under Section 363 of the code are using the COVID crisis as a basis to justify and support the hurry up or fast break process that has been undertaken in order to get these sales approved. And in all the cases I've mentioned where sales have been accomplished, none of them leave much, if anything, for unsecured creditors. Some of them, but not all, identify preferred vendors before the case is filed. The preferred vendors make deals as part of the prepackaged sale with the buyer and the debtor, and those preferred vendors are paid on regular business terms, are negotiating 40 to 60 cent on the dollar payments on their claims, while similarly situated trade vendors, trade creditors are getting pennies on the dollar, having not been offered the alternative of doing business with these debtors going forward. A company you're going to hear about, and then I'll move back really to the subject matter of this, which is the middle market, is a company called Authentic Brands Group. Authentic Brands Group has been the buyer so far in the Brooks Brothers and Lucky Brand Dungarees cases. That is 400 operating locations around the country. Their partners in those transactions are Leonard Green, who was a well-known private equity firm, and Simon Properties, who was a well-known landlord. And you're going to hear a lot more about these folks. They're very aggressive, they're very smart, and they have a business model to stick to. Other industries that I think are going to be having trouble going forward, to the extent not already known to everybody on this call. I certainly think any kind of amusement park, movie theaters, sports franchises that rely upon fans attending games, concert venues, casinos and gaming businesses, auto parts and equipment businesses, because people aren't driving and don't have the need for auto repairs that they had previously before the COVID crisis hit. I think there are going to be some real estate issues in California. I think, as people are probably aware, the governor installed or put into place a moratorium on filing of unlawful detainer proceedings that went from March until June. I believe that since June, landlords have been able to file unlawful detainer proceedings, but they haven't been able to pursue them by the service of a summons in the setting of court hearings. That changed last week when the Judicial Council, I believe, voted 15 or 16 to 1 to restart evictions, unlawful detainer proceedings, and allow them to go forward. And the start date for that is, I believe, September 2nd. So starting September 2nd, the unlawful detainer process for commercial and residential real estate is going to be starting up again. And I think anyone who is in default on a lease is presumably got a real issue starting that date. Although the backlog, which is unprecedented as far as unlawful detainer proceedings are concerned, will cause this to take a while for them to move through the system, because even though unlawful detainer proceedings are priority matters in Superior Court, the volume is just going to be ridiculous, as would be the case when you've not been able to prosecute one for 6 or 7 months, which is what has taken place so far. But there's going to be an avalanche, I would think, at least, of consumer bankruptcies, Chapter 7 bankruptcies. It may well be a very good time for a whole host of reasons that our program will present today, to be a Chapter 7 trustee or to be the lawyer for a Chapter 7 trustee, because I think their calendars are going to get very, very full very, very quickly starting this fall. Okay, let's go to slide number 3. I could stay with number 2 for the entirety of the program, but
Hey, Victor, this is David.
okay.
I apologize for being late. We had filed a Chapter 11 case last Friday where we had our first day hearings today in Central District, and we concluded. So I apologize for joining the program late. And I'll pick up here, and we can move through some of these slides, I think, pretty quickly. While the impact on middle market, in my view, of the pandemic hasn't really been felt the way it's going to be yet. It hasn't yet had anywhere near its full impact, both because of the government intervention and support, and because I think lenders and landlords have been more accommodating than they certainly would be in ordinary circumstances. It still nonetheless is very important for companies that are facing distress or potential distress to act proactively, be in a position where they're going to sustain their viability and chart a path forward. So next slide. Obviously, somewhat self-serving, but regardless, it's the reality that it's important for companies that are facing distress to hire professionals that have experience and expertise in the area. Next slide. And when we get involved, as I think is the case for most experienced restructuring and bankruptcy professionals, if there's a viable way to work things out of court, that's the goal. The goal is to achieve a consensual restructuring. And out-of-court arrangements have to be consensual, unlike if you get into Chapter 11. Next slide. So it's a situation where the company needs to evaluate its options. If it's feasible to get things resolved on out-of-court, working out arrangements consensually, that's the way to go. But when that frequently there isn't either the time or ability to get that done, the need is then to turn to other alternatives. Business reorganization through Chapter 11 is an opportunity to reset the balance sheet and or restructure operations, and may also facilitate through what's frequently referred to as a 363 sale, a cleansing process that allows parties to restructure or to sell, to move an asset and cleanse it of the debt. It's important that parties avoid delay. Frequently, parties can wait too long, so that it's too late to be rehabilitated, too late to salvage the business. Important for parties not to wait too long or to a point where they no longer have adequate funds, what we used to call a war chest. We tend not to use those terms anymore, but adequate funds and financing lined up to support and facilitate a business reorganization or a cleansing sale kind of process. Victor, you want to jump in?
Sure. It's slide number 8. We try to go through these slides and talk about important principles that can lead to a successful restructuring. Preservation of liquidity is paramount, especially in these times when sales are so uncertain and when payment from account debtors is so uncertain. In terms of cutting costs, the one mistake that I have seen clients make all too frequently in the middle market is to cut accounting personnel, the theory that they are not directly productive in driving sales of the company, but the company's ability to produce accurate information is really paramount in this context, and cutting accounting personnel is going to likely put all of the pressure, to the extent there's more than one accounting person in the company, is going to put tremendous pressure on the person who occupies the CFO position or has the CFO responsibilities, and he or she is going to need all the help they can get because they've already been under enormous pressure by reason of COVID crisis. And if it's now going to be moving into a workout, they're going to be under the same or even more pressure going forward because they have to deal with lenders and contract counterparties, licensors, trade vendors, customers, all of the participants in this process. So that is just one rule that I always urge clients to follow. With regard to government programs, and moving to the next slide, slide number 9. You know, we have worked here at the firm aggressively to pursue client eligibility for different government programs. The PPP loans are not the only ones which are available. There are some others, and we'd certainly be happy to discuss those. I don't have them here in my notes or in front of me, but I know that there are other programs which we have utilized that have borrowing available. It isn't, you know, it isn't a forgiveness situation like the PPP loan, but it is a borrowing availability backed by or coming from the government, which is on very, very favorable terms and conditions. Next slide in order, number 10. One of the things and one of the huge mistakes that clients make, particularly principals of clients, is failing to think about funding shortfalls in operations of the company before actually doing that. New money that is going to come into a business is really a very, very important aspect of any successful rehabilitation, because normally the stakeholders, particularly the lenders, are going to want to see new money coming into the company in exchange for the company's request that the lender forbear or do something with regard to the loan that modifies its terms and conditions. The lender's natural reaction or the vendor community's natural reaction is to look at the principal of the company and say, well, what are you going to do in exchange for us giving these concessions? The pain needs to be equally distributed and not just fall upon the different creditor constituencies. And so oftentimes what happens is, before that question is even asked, the principal may be putting in money to fund shortfalls. And the two problems with that is, number one, the principal should be getting concessions from creditors before doing that and should be seeking those concessions. And number two, funding like this is often something that is used by principals to shield parts of the company which are not performing from being scrutinized for their failure to perform, and postpones the willingness of principals to address difficult or sensitive issues that exist with regard to segments of the company or employees of the company who are not carrying their weight. And so those people don't carry their weight, losses result, and funding follows to erase what is a problem that is being avoided by virtue of the principal funding. So there's a lot of mistakes that I think are built into a principal funding without getting something for it and paying attention to the issues that make the funding necessary. Next slide, please. As part of your retention to represent the company, you certainly want to carefully review credit agreements, real property leases, intellectual property license agreements, equipment leases, all of the writings that apply to your client. Familiarize yourself with them and be in a position to talk intelligently about all aspects of those agreements, including whether they are profitable and worth the cost that the company is incurring in keeping them going, versus terminating a real property lease or a license agreement or an equipment lease that may be creating losses and not generating any profit. One of the interesting issues that have occurred since COVID started is around the issue of non-residential leases of real property and the obligations of debtors in Chapter 11 cases under Section 365D3 to, quote, timely perform all obligations of the debtor arising from and after the order for relief under any expired lease of non-residential real property until such lease is assumed or rejected. For the older folks, we would remember that there was a time when prior to assumption of a lease, a debtor was not required to make contract lease payments and other lease obligations prior to making the decision to assume or reject the lease. That discretion was removed many years ago by the insertion of this provision, and you'll find landlord counsel from a group from certain law firms around the country, the Ballard Starr law firm, and a few others that have counsel that do nothing other than go into court on first day hearings and enforce their clients' rights under Section 365D3. So you're going to have to deal with this if you have a landlord represented by one of these law firms. And there have been motions made. The interesting thing is there have been motions made based upon force majeure provisions in the lease that COVID suspends the obligation of a debtor to make lease payments after the filing of a bankruptcy case, notwithstanding what Section 365D3 clearly says. And I know in Delaware, debtors have had some success in getting those payments deferred. I believe in the 24-hour fitness case, which has, I believe, perhaps as many as 1,000 locations. It may not be that many. It may be 600 or 700. It's a huge number of leases that they have sought that relief. And I believe, but I'm not positive, have gotten that relief in limited instances and circumstances. So people should know that that is out there. If you've got a Chapter 11 case with a lease that is controlled by Section 365D3. Next slide, please. A little bit repetitive, so I'll be quick with this one. Want to familiarize yourself with your client's business, with the contracts and agreements it's made with various counterparties, and go through with the client every option that exists for deferral of payments, forbearance, modifications, anything that will postpone payments to a later date and allow for the buildup of cash and the creation of a cash reserve, which is everything to a business going through these uncertain times. Next slide, please. Really tying into my earlier comment about keeping accounting personnel, information is hugely important. Accurate information, of course, is just as important. What you want to be careful about and be aware of is what comments or representations or conversations have occurred between your client and creditor parties prior to the filing of the bankruptcy case. Because if you have a client that has misstated or even misrepresented, which to a creditor is probably the same thing, information or made promises that weren't kept, you're going to have a credibility problem immediately when you start to negotiate with these parties, because one of the first things they're going to tell you is they were lied to. And that puts you in the defensive. And if it's heard by others who haven't been lied to, it's going to put them on notice as well. So becoming aware of what the conversations have been and what was represented is crucially important and a very significant part of what is in this slide and the next slide, which we can go to now. That really makes it important and crucial to speak clearly and plainly to people about what the actual status is of things when you start in the workout process and before even getting to the bankruptcy process. You know, credibility is everything, and you have to know, and your client has to know, that nothing that is secret is going to remain secret, because creditors are going to find out. They're going to ask for the information that is going to disclose all the secrets, such as they are, and it's something that professional advisors need to do up front in terms of informing clients what they should be expecting, managing their expectations, and if necessary, going back to my earlier comment, replacing people in the communication chain with outside third parties who have made misstatements or misrepresentations, and bringing in a new person who won't do so, so that the credibility issue can be addressed if it exists by reason of conduct which occurred prior to you being hired. Next slide, please. What's really important, I think, is to try and identify each important stakeholder, who you need to reach an agreement with, understand the dynamics of what it will take to reach an agreement with the lenders, with the licensors, with the vendor community and the supplier community, and with real property or personal property lessors, and evaluate those individually and reduce the adverse parties as much as possible. Because if you can isolate it, hopefully down to one in the typical middle market case, your chances of being successful and being able to threaten the one holdout with a successful Chapter 11 case, which will isolate them, identify them as the holdout to the judge, and focus the Chapter 11 on overcoming whatever their issues are, is not only going to make the Chapter 11 case more successful, it's going to also make the workout negotiation much more likely to be successful, because hopefully the holdout party is sophisticated enough to understand that going into bankruptcy is not going to be a good thing for them when there has been peace made with everybody else. Okay, David.
Well, it's essential that a plan be developed for moving forward. And management needs to determine how it can get the company on sound footing again. And that may require deleveraging debt. It may just be burdened by too much debt, and that would be a balance sheet restructuring, or it may also include, or instead include, an operational kind of reorganization where certain divisions or locations or parts of the business need to be disposed of or wound down. And finally, the company should also evaluate whether a sale or merger process could be utilized to clean the slate if the other options aren't adequate. Next slide. There's some key questions, and we listed them here. Maybe they're obvious, but can you return the business to profitability? And is it enough to reduce debt and move forward? Do you also need to streamline operations and locations, as was indicated in the prior slide? And if the business is no longer viable, is there something there of value that, if combined through a merger or acquisition, may be desirable for other parties? Next slide. So when determining whether an out-of-court restructuring is feasible, obviously what's going to dictate that in part is, are there any holdouts? Are there counterparties of significance that aren't prepared to make a consensual deal, that you're unable to negotiate with in an effective way? Do you have adequate time? Because outside of bankruptcy kind of context, you're not able to force concessions to impose contractual modifications on parties. Next slide. This basically just covers what we've already talked about, that in order to maximize the opportunity to work things out of court, communication is key. And at the same time, the company may run into problems that especially if they've waited too long, that there's just not adequate time, too many complexities to accomplish the restructuring out of court. Next slide. So Chapter 11 provides a means where the business can reorganize through a formal court process. Potentially a sale could be accomplished. There's an automatic stay that goes into effect as soon as the company files Chapter 11 that provides some breathing space, puts a hold on all litigation. In Chapter 11, there's the power to, under Section 365, reject executory contracts and unexpired leases, to assume them, or to assume and assign them to third parties, even if assignment is not necessarily allowed under the contract. There's some complexities that can get involved in those situations. There's some different rules with respect to contracts in shopping malls. One of the reasons that retailers frequently utilize Chapter 11 is the need to adjust, sometimes dramatically, assuming they're able to find a feasible path forward, but to dramatically adjust their footprint, reduce the number of stores, and when, if that can't be, lease termination agreements that are acceptable can't be negotiated out of court, Chapter 11 provides for a process to getting out of those leases and capping the landlord's claims. Next slide, please.
Okay. One point in all this that I would want to make for the folks who aren't bankruptcy lawyers. The bankruptcy courts around the country, including in the Central District, have, from my standpoint, continued to operate with very little delay. The court is not closed down at all, unlike the Superior Court. And hearings have gone forward. Regular calendars have gone forward telephonically since this started. And in fact, there's a set of procedures. The court has become a subscriber to Zoom, and there are procedures that most or all of the judges have put into place to actually conduct trials. And David, in fact, in early June, I believe, conducted a trial on a contested confirmation hearing over Zoom. Exhibits were marked and identified and introduced. Witnesses were examined or cross-examined, and the entire process took place over the course of 3 days or so, and went well. It went efficiently, and so people shouldn't think that because courts may generally be closed in other, state courts, for example, which have opened very slowly, the bankruptcy court really has not been shut down at all and remains open and operational.
Yeah, and I think, Victor, most of the bankruptcy judges, at least out in the Central District now in California, are moving all of their calendars to Zoom, regardless of whether it's a contested kind of trial, just the regular calendars. We just had a Zoom hearing this morning on first day motions in a Chapter 11 case that we filed at the end of last week. And I think most of the judges are finding it works better. The participants do have compared to just using the old-fashioned court call where, obviously appearances were in person, but for convenience sake, some judges would allow you to appear by telephone, especially if you were out of town historically. The judges are finding that Zoom works better, it seems, and they will allow you to appear either by video or just audio, although, obviously, in my view, if you have something substantive that you want to discuss with the judge, you should be on the video.
Okay. A couple of points off script a little bit about the business environment that I hope and think you'll find interesting. The supplier clients that I've represented in the 3 or 4 cases in Delaware and the Eastern District of Virginia are all situated in Southeast Asia, India, Sri Lanka, Malaysia, and they're very, very large companies, $1 billion in sales or more. And they have told me that their sales to Europe and Asia are fairly steady, and that their sales to the United States, which of course is the major customer, if you will, of these various denim and other kinds of goods and services, goods that are supplied to companies like Brooks Brothers, that their sales to the U.S. are off 40%, which is a staggering number for companies of the size that we're talking about here. The second anecdote concerns a client that was in trouble with its lender, ironically, because its lender was itself insolvent and couldn't make contractually required advances to it. And we literally got down to the last minute of getting ready to file a Chapter 11 case or preparing to file one when they worked things out and reached an agreement for the lender's obligation to be retired. But the lender, in the process of these disputes that it had with my client, served payment demand notices on the client's major customer. And this, of course, made the client very, very nervous that the customer would seek supply of denim and other goods that the client supplied from an alternative source. And after the workout with the client's lender was finalized and things were back to normal and the demand for payment by the lender was withdrawn, the client spoke with its customer and apologized profusely for all the trouble that it had caused. And the customer looked at my client, or proverbially looked at my client, askance, and said, "What are you talking about? This is occurring with every single supplier in our supply chain. You're better than 95% of them, and we are seriously concerned that we're not going to be able to carry the products that we sell to our customers because of the disturbance in our supply chains caused by COVID-19. And this is a mall retailer that apparently is still healthy, has many, many hundreds of stores around the country and around the world. But it just was a wake-up call to me about how severe and how deep the crisis is. And if at any point that lenders and other parties start to enforce their rights, I just don't know how many of these companies that have been so severely damaged are going to survive, or survive without a lot of help. It is my observation and the observation of some others that at least the lender community, the asset-based lenders that are the lifeblood of so many of these middle market companies, have been so far sitting on their hands and not taking aggressive action, either because they know where it's going to lead, they don't want to be the first one to start aggressive conduct that may draw bad publicity if you're Wells Fargo or the Bank of America, or they're just flummoxed about what to do given the unprecedented nature of this situation. I'm sure that they're getting clarity and they're deciding on game plans, but when David said earlier that some of the middle market effect hadn't been felt yet around the country and certainly in Southern California, I think there are a lot of potential tumblers that are out there, including and starting with perhaps unlawful detainer proceedings that are going to create different levels of a waterfall or different intensities of a waterfall with respect to clients' needs for workout or insolvency advice. And really, I know this next comment, of course, sounds self-promoting, and I don't mean it that way. I really don't. But seeking help from people that understand this process at the earliest possible time, and hopefully before the consequences of what has occurred are actually felt or realized, is 100 times out of 100 the cheapest and the best advice that you can get. Once things proceed forward and degradation in the business starts because of lack of working capital, lack of supply of necessary merchandise or component parts to the client's product, lack of denim, lack of other kinds of clothing that companies sell, that's going to start a downward spiral, and that's going to make rehabilitation or survival of the business much, much more difficult. Going back to slide 21, the positive effect of a plan of reorganization is, really a tremendous tool. It does extraordinary things in terms of the effect that it has on creditors and equity holders. It provides for a statutory scheme for treating similarly situated obligations fairly, and it also creates a whole host of revised or modified or completely changed or terminated contractual relationships as compared with the contractual relationships that existed before the bankruptcy case was filed. And once the plan is confirmed, the revised contractual relationships that the plan of reorganization contains becomes binding on creditors. Next slide, please. What can a plan do? It can deleverage debt and reset the balance sheet. It can streamline operations by getting rid of losing business segments, losing business subsidiaries. It can allow for terminating personnel who aren't carrying their weight or aren't being productive. That is all finalized because upon plan confirmation, the company actually gets a discharge, a formal discharge under section 1141 of the bankruptcy code of the pre-confirmation debt that the company was carrying. Next slide, please. We talked earlier about the ability to use section, this is slide 23, section 363 of the bankruptcy code as a methodology in large or mega cases to maintain going concern value, cut off successor liability, accomplish an immediate deleveraging of the business, and address issues including lack of working capital and the other business changes that occur when a sale happens and a new entity with a view of the world that is different and much more objective comes into place. In the mega cases where the sales in Lucky Brand and Brooks Brothers are taking place, this Purchaser Authentic Brands Group has a completely different point of view with respect to leases. Their point of view of leases is not that there should be contractually agreed upon payments. Their point of view of leases in malls or otherwise is that the rent paid to the landlord should be a percentage of sales. and that makes the landlord a true partner with its tenant, and it puts the burden on the landlord of the mall, of the location where the business is located, to drive customers into the store areas or the mall, wherever the store is situated, and removes fixed cost, a huge number of fixed cost items, particularly for businesses that have dozens or hundreds of operating locations. This is the new way of the world, at least as far as this particular company is concerned. And it's going to be very interesting to see how they do going forward and how the landlord and tenant communities react to it going forward as far as new leases or lease terms are concerned. Next slide.
Why don't we stay on the one here that I'm looking at? Victor, I'll jump in.
Go ahead, David.
One of the complaints about Chapter 11, especially in the middle market, is that it's just too expensive. And, that's often not an issue for the mega cases because the dollars at issue are so substantial. So in order to try to streamline Chapter 11, an approach that we'd like to take is to try to prepackage the exit plan, the plan of reorganization, get it negotiated pre-bankruptcy, work with the key stakeholders, the secured creditors, other key players. It's very, very common these days to file cases where you have what's called either a RSA, restructuring support agreement, or a plan support agreement in place prior to the commencement of the case, and you have a detailed plan term sheet as part of that. Now, frequently those agreements don't include all the players. The unsecured creditors may get left out in the cold, basically, especially because a lot of these cases are underwater cases where the secured debt is probably in excess of the current value of the assets, and certainly on a liquidation basis. But for example, the Chapter 11 group of cases that we filed end of last week, we had a plan support agreement in place and then negotiated with the secured lenders and investors a plan term sheet. Next slide. And that helps streamline the process because you hit the ground running and can shorten the time period and expense in Chapter 11. Now, last year, 2019, Congress passed a new subchapter, Roman numeral 5 of Chapter 11, that was designed to streamline the reorganization process for small businesses. At the time that went into effect in February of this year, the impact of the pandemic really hadn't yet been felt, and there was a cap of $2,725,000 in debt, non-contingent liquidated debt, for a company to be eligible for relief under this subchapter 5. As part of the CARES legislation in March, that cap was increased to $7.5 million of non-contingent liquidated debt, which can make a big difference because you may have a $50 million revenue business, next slide please, that only has $7.5 million of debt. So it can involve, even though the debt amount is relatively small, a business that's not tiny. And it's designed to make it more efficient and less expensive, and also eliminate certain of the substantive and procedural steps, next slide please, involved in Chapter 11.
David, can I interject just one sentence?
Sure.
The increase from $2,725,625 the last time I looked was scheduled to end on January 1, 2021. Presuming that is still the case, it imposes a timing issue with regard to clients that fall within these debt limitations.
I don't think it's January 1, Victor. I think it was designed to last 1 year.
Okay.
But still, your point is just as valid in terms of, if I'm right, it's March. If you're right, it's January. But it was a limited time period. Now, I think there's probably a significant likelihood that that may get extended, but it may not. And right now, there's a period where that expires unless Congress takes action. But I believe it was a 1-year program that I think went into place at the end of March of this year.
Thanks, David. Go ahead.
Among the substantive changes include they're a mixture of procedural and substantive. You don't need to do a disclosure statement, which is a step along the way in the process. So it can shorten the process to get to getting a plan confirmed. Next slide, please. There's no creditors committee unless the court otherwise orders otherwise. There's no U.S. trustee fees. There's no absolute priority rule, meaning basically that in ordinary Chapter 11, in order for old equity to retain ownership in cases where unsecured creditors aren't getting fully paid, old equity, generally speaking, is going to need at a minimum to make what's called a new value contribution, put new money in, and potentially to show that they've marketed the equity in the reorganized entity. As crazy as that is, in small businesses, there is no such market in the real world in most instances, but that is eliminated. So there's no absolute priority rule. There's no requirement of an impaired consenting class in a plan. So in Chapter 11 plans, ordinarily, if it's not under this subchapter for small business, if you're going to be impairing a class of creditors, meaning altering their rights, you have to have at least one impaired class that's not controlled by insiders that vote for your plan. That requirement's been eliminated. There's no competing plans in this small business Chapter 11. So in ordinary Chapter 11s, the company that files Chapter 11, the debtor in possession, has a period of exclusivity, which can be terminated or may otherwise expire, and then potentially may face a creditor's plan, a plan presented by some third party besides the debtor and its ownership and management. That doesn't occur in this subchapter 5. So there's both procedural and substantive benefits from a debtor's perspective that may make the case go more quickly and on a less expensive, at less cost. Next slide, please.
David,
so Chapter 7, Victor, I was just going to jump in and run through it quickly, but go ahead.
David, I'm going to skip Chapter 7, and why don't we go right to assignments for the benefit of creditors? The next slide, please.
Sure, that's fine. And Victor, jump in if you'd like, but an ABC, or assignment for the benefit of creditors, is a state law-based alternative to a formal federal bankruptcy case, and it can sometimes be a very effective tool, especially if you're trying to transfer assets free and clear of unsecured debt or wind down a business in a low profile way, because, for example, in California, it's non-judicial, there's no public record. It was very heavily used in the dot-com and technology downturns at the beginning of this century, and in particular because the VCs really like that vehicle, and it can be utilized if there's secured debt with the secured lender's consent, where you can sell the assets and cleanse them of the unsecured debt, both known and unknown liabilities that a sophisticated buyer doesn't want to potentially be undertaking, be responsible for, and cleanse the assets. Unlike Chapter 11, however, you don't get a nice court order saying these assets are transferred free and clear of liens. It's because it's non-judicial and you're not in court. On the other hand, you don't have some of the expense and procedural requirements and complications of being in court. So it's not the right solution to all situations, but especially cases that don't have a lot of complexities. Tends to be smaller situations, but doesn't have to be, because if you have the right situation, it can potentially be a good solution to move the assets free and clear of debt to third-party acquirers.
David,
next slide.
David, just want to interject quickly. Another vehicle that has some similarity that we've done, I've certainly done quite a few times with the secured lender, is what's called a voluntary surrender of collateral to the secured lender under California Commercial Code Section 9620, where the secured creditor agrees to accept its collateral in full satisfaction of its secured claim. And doing that kind of transaction, which often involves all of the company's assets, and simultaneously with the surrender of collateral, the secured creditor then transfers it to a buyer. And so that is another way of accomplishing the transfer of the assets to a buyer through a secured creditor, and the secured creditor exercising its rights under Commercial Code Section 9620. Thanks, Dave. Go ahead.
Yep, next slide, please. We can move on because we've covered this on ABCs. Next, keep going. Okay, so let's go back to that last slide. Just kind of sum it up, it's very important to avoid delay and maximize the opportunity to be able to sustain or rehabilitate a business that's being impacted. Important to be proactive, preserve liquidity, protect the viability of the business before it's too late. As we've discussed, early action can increase the likelihood of being successful. Taking a collaborative approach if possible, if too many bridges have not yet been burned, through good communication with key stakeholders, as we've emphasized, is important. And then when an out-of-court restructuring is not feasible, that's when we turn to the alternatives, whether it's Chapter 11, if it's a small business. This new subchapter is appealing. If it's Chapter 11 and you've got a client who's proactive enough and capable enough, if you can prepackage the case and enter into a restructuring support agreement or plan support agreement and move that Chapter 11 forward in a more kind of certain, effective and quick manner, then you can frequently limit the risk and expense. And an ABC or friendly foreclosure, as Victor was describing, can potentially be other methods to move assets on to new acquirers and cleanse them of the overhang of debt and potential successor liability.
Okay, well, I think we've gone over a few minutes. We're tremendously appreciative of everybody's attendance, and we hope the program was interesting. You know, I brag about David probably too often, but when it comes to assignments for the benefit of creditors, there simply is no one more knowledgeable about them than he is. And so, not that we are limiting ourselves in any way, but that kind of situation comes up. He really is an excellent person to reach out to. Thanks very much.
Thanks, everybody. If you have questions, feel free to email them. Bye-bye.